Welcome to today's episode of The Law Sit Down. Joining me today with Salah Malik, who's the CEO and founder of SAL International, whose firm turns 6 this year. We have a walking legend, an authority on international arbitration who needs no introduction, but I'm going to do a brief one anyways. He's been into more or almost 700 international arbitrations till date and international litigations, from ICC to exit arbitration. His name is everywhere. He's a legend indeed, but he's very cool about it. Well, one of the most formidable and interesting actions he held, or positions he held, was chairing the very interesting arbitration center of SIAC, their Court of Arbitration. He's also taught as a professor of law in many prestigious universities, such as Harvard, Stanford, and even University of Peking, and held many advisory opinions. The one and only, the chair of International Arbitration Practice Group at Wilmer, Hale, Mr. Gary Bourne.
Thank you, Khaled. That's extremely flattering. It's unwarranted, but thank you. Thanks also to the Law Editorial for having me, and also Sarah here with you today.
It's a pleasure really to have you. And I take it that today, given that we're in Egypt, it's your first visit. Am I correct?
Actually, not correct. I've been to Cairo a half dozen times or so, and of course, no one can come to Egypt without visiting Dahab and Hurghada and taking advantage of the diving opportunities.
Okay, now we're talking. Well, given the circumstances, you're officially at our winter, and we can say that winter it has indeed come to Westeros. It's always been one of the most interesting analogies we see when it comes to your name and your engagements. The "is winter coming" message. I have to admit, personally, I always find it intriguing, but I always ask myself, about 10 years ago, you first gave us this very message, and you still give it in a lot of occasions. Why the analogy with Game of Thrones?
So I'm impressed that you actually got the title correct. The correct title for my talk, which somehow has gone viral for a decade or more, is winter coming. It's often misquoted. It's often described as winter is coming, not a question, but a declaration. And in fact, 10 years ago and still today, it's a question. And the reason that other people, and occasionally I, continue to ask that question is because of the external environment that international arbitration sits in. It continues to have massive support all around the world. The business community, I think every sector of the business community continues to regard international arbitration as the best, not perfect, but the best available means of dispute resolution. Many governments as well, for important sectors and important aspects of their dealings, both as states and commercial actors, also regard international arbitration as the best, or at least the least worst, means of dispute resolution. Despite that, though, there are critics on both sides, both extremes, I would say, of the political spectrum, both the far right and the far left, criticize arbitration because, in their view, it undermines the ability of the state, whichever state they favor, to exercise its authority over businesses and ordinary citizens. And as a consequence, I think there's, in a sense, an eternal question: is winter coming to international arbitration? There have been periods in the past when indeed it has come. The U.S. courts have referred to the dark chapter in American legal history when arbitration wasn't favored, the 19th century, and so we've moved past that. But you still hear echoes of that, particularly in the academy, particularly on the far right and the far left of the political spectrum.
Okay, so from considering that these are the two extremes, so from your point of view and within the same theme, what would be the sort of centered or the a bit neutral take on this? in terms of this question?
So I think I think a centrist and objective criticism of arbitration, both international and domestic, would be the pragmatic benefits that it brings, or in some cases doesn't bring. Arbitration aspires to provide what I call the 6 E's, 6 advantages as compared to the alternatives, and this is especially true of international arbitration. It promises to be more expert, and as a consequence, more expeditious and efficient. It also promises to be more even-handed, and because of the New York Convention and other international treaties, more enforceable. And in today's era of remote communication, it promises to be more electronic than the alternatives. It's more expert because parties can choose the decision maker. If you have a construction dispute involving a dam in, say, Kuwait, you can pick someone that actually knows about constructing dams and someone else who's expert in Kuwaiti law. You don't get a judge who, bless her soul, has to do tax cases and employment cases and administrative law cases and everything else in the world but a construction contract for a bridge in Kuwait, or a dam, or some other bit of infrastructure. And because the arbitrators that you choose are more expert, your proceedings are also faster. You don't have to educate the tribunal. They're more expeditious, and because, as we know with lawyers, time is money, it's therefore more efficient. International arbitration is also uniquely more even-handed than the alternatives. It's more even-handed because the parties themselves agree on the arbitrators and they exercise control over what their counterparty selects, and because the arbitrators are bound to be independent and impartial. The contrast between that and national courts, especially when you have a governmental entity, but even among private parties, when one party inevitably must litigate on the other party's home turf, international arbitration, typically in a neutral forum with an impartial, independent tribunal, is more even-handed, which businesses and also governments prefer. And finally, international arbitration is more enforceable because of the New York Convention, 170 or so contracting states that promise to give effect to international arbitration agreements and arbitral awards. There's no comparable mechanism for national court judgments or forum selection agreements. But I would suggest that, in answer to your question, a neutral criticism, a pragmatic, business-oriented criticism of international arbitration is that it doesn't always provide those 6 E's. It sometimes has arbitrators who are not as expert as they ought to be, who are not as expeditious as they should be. And I would suggest that the true criticisms and true improvements for international arbitration would focus on improving each of those 6 qualities. I think it's doable. It's very different than the extreme criticisms of arbitration as somehow eroding state authority or occurring in smoke-filled rooms behind dark curtains. It aims to promote the real values of international business and international arbitration.
When we speak of one of the E's, the enforceability, I'd like to go back to your very first council work in international arbitration, the Rainbow Warrior.
It's a long way back.
I'll try to keep it brief. It's not common that someone's first appointment would yield a very powerful award against a state such as big as France. And for and I believe they were a environmental group. They're not some shady major corporation. So it's a little bit uneven, but it was enforced, I believe, and the award was big at the time, I believe, as well. So do you believe that the landscape of enforceability have changed dramatically since the Rainbow Warrior up until today, considering that some of the circumstances still persist?
That's a great question, Khaled, and for the benefit of some of our viewers, the reference is to the Rainbow Warrior arbitration, which was my first arbitration. We represented, a little unusually, an environmental protest group, Greenpeace, who'd had the misfortune of having their flagship vessel, the Rainbow Warrior, dynamited and ultimately sunk by French secret agents in Auckland Harbor in New Zealand. The effort on the part of the French was to prevent the Rainbow Warrior from interfering with French nuclear testing in the South Pacific, which fortunately has been subsequently stopped. The Greenpeace came to my law firm at the time, based principally in Washington, D.C., because they were convinced, like many people, that this had to be the work of the CIA, the Central Intelligence Agency. Nobody else would make that big a blunder, the thinking was. I could understand that thinking, but it was in fact incorrect. It turned out that it was the French that had done it. And Greenpeace nonetheless stayed with us, and we negotiated an arbitration agreement with the French government. We sought the 6 E's in a very fundamental sense. We sought an expert tribunal that would be even-handed and that would produce an enforceable result in a fairly prompt period of time. We didn't want to have to litigate in multiple courts, face defenses of forum nonconvenience or state immunity and the like. And the French, too, wanted an even-handed and sensible, pragmatic outcome. We had some difficulties. It turned out the Rainbow Warriors was a 35-year-old North Sea trawler with a market value of around 35,000 pounds at the day. That is worth a bit more then than it is today, but it still wasn't what we'd hoped for. Fortunately, it turned out the tribunal properly concluded that the Rainbow Warrior wasn't just a boat. The Rainbow Warrior was instead a living symbol of Greenpeace's commitment to the environment, and its value could only be measured by the amount of volunteer time that had been put into it by Greenpeace members all around the world. The tribunal concluded that that was worth a good number of millions of dollars, which enabled Greenpeace to buy a replacement vessel and continue its protest activities. The French government, to its credit, both negotiated that arbitration agreement and also complied entirely with the arbitral award. And I think the landscape from then until today, in a very fundamental way, hasn't changed. The landscape today is that more than 90% of all arbitral awards are voluntarily complied with. That doesn't even count the number of disputes which are referred to arbitration, but never produce an award because they don't need to, because the parties settle their dispute in a sense in the shadow of the law. The threat of an award that can be enforced induces one party or both parties to settle valid claims against them. And that is, in my view, an extremely impressive enforcement record, even without recourse to national courts to actually coercively enforce the award. In fact, in that 10% of cases where an award is actually taken to enforcement, there's a very high rate of enforcement. Annulment of awards in the arbitral seat is extremely low, on the order of 10-15% in most jurisdictions. In some jurisdictions, it's significantly lower than that. And successful recognition, even in this post-Cold War era, is in most jurisdictions readily obtained. The recognition rates are again in the region of 80% or so of the remaining 10% of awards which actually need to be taken to court to be enforced. And we always have to remember that arbitration, notwithstanding the 6 E's, isn't perfect. Not every award deserves to be enforced. And the fact that some awards are set aside, the fact that some awards are denied recognition is not a sign of dysfunction. It's exactly how the system is meant to work. That's why the New York Convention in Article 5 has 7 different grounds for non-recognition. Some awards don't deserve recognition. And in my view, that system, a little bit like the result in the Rainbow Warrior, produces results that enforce most awards, but not all awards, and that's exactly what should happen.
Well, this leads to one major question at this point when you say even-handed. I mean, I can tell that enforceability may be a great argument in favor of arbitration, even considering left and right views. But when we say even-handed, can we say it's the same argument considering the rise of third-party finance?
So that's a very good question. Third-party funding has, as an innovation, had a significant impact in some sectors. Many arbitrations are not infected by third-party funding. The significant majority of all arbitrations, like all litigations, continue to be self-funded. You don't have third-party funding. Nonetheless, the availability of third-party funding both creates access to justice in a wide range of cases and is also used in a significant minority of cases. As a consequence, it's very important to take into account how third-party funding affects the arbitral process. And to some extent, as with litigation, one needs to make sure that the presence of a third-party funder is taken account in both the litigation process, for example, disclosure of documents and inquiries as to who's really in control of the litigation on the one, or the arbitration on the one hand, but also importantly, disclosure of potential conflicts of interest vis-a-vis the arbitral tribunal, and for that matter, a national court judge. And most arbitral institutions, the IBA as well, now take into account the existence of a third-party funder, required disclosure of the third-party funding arrangement and the identity of the funder, precisely in order that the members of the arbitral tribunal can, should they have connections of some sort with the funder, can disclose that to the parties and potentially be subject to a challenge. In most instances, there wouldn't be a valid basis for a challenge, but nonetheless, the parties deserve to know about the potential connection with a third-party funder, and should they choose to do so, have the opportunity to challenge the funder.
But would you believe that from maybe a little bit of a superficial standpoint, but wouldn't that hinder arbitration agreements by default, just considering the fact that as someone who's going to recourse to arbitration, an investor perhaps, would be between one of two fires. It's either they can't go to arbitration and they would lose entirely their ability to arbitrate under a BIT, for instance, or they would go seek third-party finance. It's disclosed, it's compliant, but they have another bill to pay just because they cannot afford to finance their operational or their legal operations under the arbitration.
I mean, there certainly are instances where precisely because its legal rights have been violated, a party can't afford to vindicate those legal rights. It doesn't have the money to spend to pursue a claim against someone that has taken its property or breached an important contract. Third-party funding reduces the risk of that happening because it makes available funding from someone else so that the injured party can pursue its rights. That doesn't mean it's a solution in every case. In some cases, the investor may, either because of what its counterparty has done or perhaps because of extraneous circumstances, simply not be able to continue in operation, may be wound up. There are, of course, in insolvency regimes, mechanisms whereby a receiver or a trustee could also pursue those claims. And again, the availability of third-party funding for somebody like a receiver or a bankruptcy trustee would, at least in my view, increase access to justice and hopefully act as a deterrent against wrongful conduct, whether by a state or a private party.
Okay, well, considering this and considering the needs of the international business scene, would we, considering again the efficiencies or the 6Es or of the international arbitration, would international litigation really come close to giving the same alternative to the business community or generally the international sphere of business and states? Are we talking almost a little bit of an identical spheres of work, or is the difference so major you can still make notice of it?
It's a great question, and I'm not sure that there's a single recipe or formula that answers it for all circumstances, for all cases. What's critical at the end of the day is that parties have the choice, that commercial parties have a choice to either arbitrate or litigate And if they are going to arbitrate, ad hoc arbitration or institutional arbitration, if they're going to litigate, in which courts, under which law. What's critical is that the availability of party autonomy, which is celebrated in the New York Convention and many other international treaties, be preserved. Parties may sometimes choose not to arbitrate. They may prefer to litigate some sorts of disputes. Financial institutions historically have preferred litigation, in many cases because they can, by virtue of their position in the transaction, require litigation in their own home courts where their counterparty's assets are located or at least subject to security arrangements. Financial institutions nonetheless sometimes choose arbitration because they want the possibility of the 6 E's, which we've described. Outside the financial sector, businesses need to make their choices. Businesses often prefer international arbitration. In domestic situations, they sometimes prefer arbitration as well, although the advantages are somewhat less pronounced. But in some circumstances, businesses prefer litigation, either because of past experiences or because of the particular structure of their business. There's no single recipe that dictates how every business should resolve every type of dispute. Some businesses may have arbitration provisions in some contracts and not in other contracts. And there's nothing unusual or anomalous about that. It's simply a reflection of the complexity of contemporary business life.
Yes, that is indeed the case. But when we refer to the finally, which I believe it's rather new considering the practice of arbitration, but in the age of artificial intelligence and how it's really embedded in almost every tool that I would believe a practitioner, whether an arbitrator or a counsel, would be using, are we ought at one point to see artificial intelligence more embedded into international arbitration, but more of, or not as a tool, an assistive tool for writing or anything, but maybe as a living, thinking part of the deliberation for words, for instance?
This is a new viral theme. It's not anymore is winter coming, it's is artificial intelligence coming. I think I like the original theme a little bit better. It has a nicer ring to it. But no doubt artificial intelligence is coming, and the real question is in what form. Even today, parties are using artificial intelligence, most obviously for disclosure, review, and in some instances, legal research. One has to be very careful about that. Artificial intelligence is 2 or 3 years old, and it sometimes makes up stuff a bit the way your 2 or 3 year old child makes up stuff. There's a classic American example where a party proudly cited a decision in its submissions to the court, a decision which never existed and which AI had made up out of whole cloth. And I suspect that those sorts of teething difficulties will be overcome in time, but they remain a real issue. More problematic, I believe, than the parties using AI for disclosure or research or initial drafts is an arbitral tribunal doing that. It is a long-standing tenet of international arbitration law and practice as well that the obligations, the mandate of the arbitrators, the arbitral tribunal, is personal to them. They are chosen precisely because of their expertise, precisely because of their judgment, their personal qualities. And for them then to go off and assign or subcontract their mandate to somebody else is improper. If I'm chosen as the arbitrator, I can't have Ms. Malik do it on my behalf, even if she would no doubt do a better job. And equally, I can't have AI, a 2 or 3 year old, do my mandate instead of myself, even, I would suggest, even to the extent of just a first draft or a recommendation, at least not absent disclosure to the parties, quite clear disclosure to the parties and their consent. I think AI changes the character of an arbitral tribunal's functions, and if it is going to be used, must be disclosed quite clearly. And even then, I think one has to think hard about its impact on the enforceability of a decision.
Well, sorry, I'd hand it to you.
Thank you, Gary, and thank you, Khalid. Really interesting. I'm going to talk about non-law, mostly non-law. At the law, we like to kind of keep real talk, and I'm proud to wear my hat as an ambassador for the UK. Gary, you're an international bestseller in The File. And those of you who don't know it, a captivating heroine who becomes a target of US and Russian intelligence agencies because she stumbles across a cache of Nazi files. It's been said, I think before, you've said that your inspiration was through a long trip in Africa, and that inspired you to write this novel. Was there any other inspiration at play when you wrote this bestseller, international bestseller?
Thank you for that, Sarah. I always like plugs for The File, which you can find on Amazon. Another little plug there. The File was a product, I think, like many fiction works, of lots of bits of reality. When I wrote The File, almost every character, almost every scene came out of some bit of my life. One doesn't make things up entirely out of whole cloth. Sometimes I think my opposing counsel in arbitrations that I do does that, but I think most writers don't make up everything. You take things that you've had personal experience with, and you trim them, you tailor them, you Photoshop them, and put them in your thriller. It included things from my professional life, my personal life. It did start, as you said, though, in the jungles of Uganda in Africa.
It's fascinating, Gary. Obviously, you're internationally studied, read as a legal writer, and all your treatises and all your books. And then you switch your hand to this international best-selling kind of spy novel. Did you find your legal background, your legal writing skills assisted? Did you like breaking away from the mold, or they played no part in writing this novel?
That's a great question, Sarah. One would think, because I've spent my life in a very real sense writing things, that all that experience would be hugely helpful in writing The File, a fiction work. And to some extent, perhaps that's true. Perhaps I felt more comfortable starting out to write something because I'd written so many other things before. But in fact, once you actually start trying to write a fiction work, when you start trying to write dialogue, when you start trying to describe how a scene feels, all that legal training really isn't of much value at all, and at least arguably it's a handicap, not an advantage. You need to entirely change your mindset, which can be both very, very liberating on the one hand, but also hugely challenging on the other. You know, as you begin to write a chapter, that it will involve these 2 or 3 or however many characters. You know that it will take place in a particular location at a particular time in the sequence of your story, and therefore you'd think this is easy. I can just do this. But there are 1,000 different or 1,000,000 different ways that you can have the meeting described or the encounter described. It can be at one time of day or one time of night. The characters can be wearing one set of clothes or another. They can have one set of attitudes or a different set. And it's enormously liberating to have that freedom. And on the other hand, when you sit there looking at a blank piece of paper, I wrote this thing longhand on long plane trips mostly. So as you sit there looking at the blank piece of paper in your tablet, it can be extraordinarily daunting.
And you've kind of answered, I guess, my next question, but it's the $1,000,000 question of where do you get the time? When did you write this novel? And everybody, and even our viewers, will be like, he's so busy and he's everywhere. How did he write? Where did he find the time to write this international best-selling novel?
Oh, you haven't been listening. Didn't you hear about the 6 E's? I'm expeditious and efficient. No, seriously, a lot of very long plane trips to very far off places. And at some point I got tired of sitting there watching movies or looking at my laptop, and I decided, oh, I'll write a spy thriller, whatever.
Fantastic. And that leads nicely into the next question, actually. Both the inspiration behind the novel and generally, as we know you, Gary, you've been described as having the soul of a wanderer. You ventured far and wide across the kind of earth, if you like. Is there anywhere you haven't visited that is on your bucket list or you'd like to go to?
So I'm not sure about that. I think that some of the most exciting places that I've wandered to recently have been underwater. I've been scuba diving in various places in the world, and I think, although I'm not exactly sure which ocean I want to be underneath or inside of, the next places that I want to wander to are definitely beneath the ocean, not above it.
Fantastic. On a different note, we're experiencing quite troublesome times here, especially in our jurisdiction in the Middle East, and a lot is going on. Do you think it's about time that an international tribunal such as the ICJ steps in and needs to restore order, peace, and give justice in this region? What's your view?
It's a great question, and if you think back to a couple of the examples that I've given thus far, I think you can foresee my reaction. The first case I worked on arose out of what was ultimately a military or paramilitary attack. The French Secret Service dynamited an innocent vessel in a peaceful harbor, but arbitration successfully resolved much of that dispute. The ABA arbitration arose out of 45 years of civil war between South and North Sudan. The ABA arbitration didn't solve that civil war. Perhaps nothing ultimately will solve those various conflicts, but it played a role in creating the framework for a settlement, and in the longer term may well produce a complete resolution. I wouldn't pretend that any institution could resolve things finally in the Middle East or anywhere else for that matter, but I do think, as with the Rainbow Warrior, as with the ABA arbitration, dispute resolution by an independent adjudicator has a very important role to play in resolving both disputes here in the region, but also elsewhere. It ultimately takes the parties' agreement to identify those areas where they can submit matters to independent dispute resolution, which will bind them whether they like the result or not. But I do think on both sides that sort of mechanism can play an important role, and indeed should.
And finally, Gary, there's a tradition in the law. We always ask those we interview to pass on words of wisdom. There's many who will be watching this interview, and you are an inspiration to many generations of practitioner. What's your words of advice to those who are coming through the ranks? They want to have a fruitful career in ADR and international arbitration. What would you tell them, the best kind of takeaways from your perspective?
That's a almost impossible question to answer. I'm sure that many people who've sat in this chair previously have given much better advice than I could. I think that the advice that I would give is largely don't take other people's advice. Follow your own instincts, your own sense of what's right, what's wrong, what's good for you. I do think that it's important never to pass up opportunities. Often one thinks, well, there'll be another case like this, another opportunity to write an article about this other topic coming along. I don't need to jump at this one. I would suggest never do that. Treat every opportunity like it's the only one you're going to get, and seize every opportunity that you possibly can.
Great advice, thank you. Thank you, Mr. Gary Bourne, and thank you to the law for this episode. Thank you, Khalid.
Thank you, Sarah. Thank you, Gary. And we're signing off from A Day to Remember.